Hi, small business owners. It's Harpreet Singh from Sharon Law Firm. Today, I want to talk about general partnerships and the authority issue which is involved most of the time in legal disputes. And third, about accidental partnerships. So, as I have discussed in the previous video about general partnerships are very common way that the people get into business together, and those are like very informal way to work as together in a business and just make a living. So you just need a business license and at most fictitious business name if you want to use it, or you can just use your name alone. You don't need any filing with the Secretary of State. You don't have to do any kind of formal requirement which is required on corporation or LLC side. So it's a very simple entity to just form and just work under. When I say entity, because most of the people have hard time to understand, when you are just even forming a partnership, suppose you are two people coming together and you have formed this partnership and bought a restaurant under that. So there are like these two people who becomes the agent of this partnership. So partnership in itself becomes an entity. So it's becomes in itself a legal person. It's not a human being, but it provides it's the existence to have some legal presence when you are filing something in court or someone is taking an action against you. So just to understand simply, when you are forming a partnership, you becomes the agent of that partnership and you are the person through which this entity moves. Okay, so you have formed the partnership and you are just enjoying and your partner is working well with you from few months, but down the road he signs an agreement with someone and you don't know about it, and you just get a letter about a month after with a bill of $10,000 for installing some kind of an equipment which you were not aware about. And you were thinking, okay, I have not bought this equipment, and you just call the company which have sent you this invoice and you just say, okay, I have never bought this equipment, so why you're sending me this bill? And that company tells you that, okay, your partner has contacted us and we sent the agreement and he signed the agreement and we just shipped the product and we are just asking for money for that product. And you were just thinking, okay, I don't know about it, so and without my authorization, how you can ask me for money? This agreement is not valid. Okay, is that right? No, that's not legally right generally. Because as an agent, your another partner has complete authority to do an act on behalf of this partnership. So if your partner binds this partnership in some kind of agreement, he has complete authority for that by default. Sure, there is another situation where this company which sends the equipment already knows that the partner who signed doesn't have the authority to do this kind of act while working under this partnership. So sure, in that situation, the agreement would not be a valid agreement because the person didn't have the authority, so there is no binding on the partnership itself, the entity. However, means the equipment owner can pursue other claim against that partner who doesn't have the authority to sign. But in general, most of the time, third party doesn't know. A person sitting somewhere who don't even know about you, you ask something, you sign a piece of document, and that person presumes that you are a partnership, and obviously you are a partnership, and he just sends the product. You are bound by it. And sure, any kind of creditor will first claim money from your partnership entity. And then he or she will come towards the assets of the individual partners. But still you are on hook now, because most of the time I have seen mom and pop businesses, they don't have assets of the partnership entity itself. Most of the time they are using just their personal account, or even if they have a business account, they don't usually have much fund in them. So the partnership itself doesn't have much assets. So now if you don't have the assets, so the person will just go towards the personal assets of each and every partner. So it's a very frightening situation, and I have seen few cases such a thing happened, and the other partner have no idea, but still unfortunately he is bound by that. Okay, so how to avoid that situation? And so there are few ways you can, as I always mentions, I think even in the previous video, you should have a partnership agreement. Your partnership agreement will provide specific conditions and specific guidelines or provisions through which you will work out through this business, and each and every person know who has authority to do what. So it's always good to maintain that in writing, and it's always good to have, especially when you're dealing with big contracts, especially to provide your partnership agreement. Or one thing you can do, which is not required by law, you can file a statement of partnership with Secretary of State. You can record that in your local county. You can record your partnership agreement in local county. If you feel that it would be good to work with this person, but you are not sure at this point, so you can file that in your county, and at least that would provide a constructive notice to other people who are working with your partnership entity, that who has authority to do what. But most of the time people don't do that. And also I think sometime means even I would not be recommending that, because the partnership agreement becomes a public document once you file this in county, and you would most probably don't like to do that, because your competition can see, okay, what's the structure and how much percentage this particular partner has out of this entity. So most probably you will not do that. But just make sure that the other partner has the authority to do any kind of act on behalf of partnership while working under the business of partnership and doing an act which is beneficial to the partnership. So you have to have that idea in your mind and just work along that and just choose a safe partner. So let's move forward to the next topic, which I have just mentioned, accidental partnership. How accidental partnership happens? Just see a factual situation. Okay, person A, suppose he just graduated from college thinking about a project to work on, and he just thinks about a friend who has good skills either in IT or in different other work in that business. So he asked person B, okay, why not you come together and okay, I will just give you some money, you have this skill and I just want to use your skill, and I will just pay you once a month when I just usually get my check. So that kind of relation, it just moves on for months, and now the business is growing, and the person A is getting quite a money in his bank and getting good profits out of it. And he just asked now the person B, okay, I don't need you now, so okay, why not we just move on and just work on our ways out. And so the person B would, if he is somewhat smart, he would be probably thinking about, okay, I have just put my sweat in and I have contributed these many hours and it seems not fair to me. He doesn't know what to do or what to ask. Then he just makes an appointment with a legal counsel and just ask him, okay, this is my situation. I'm not seeing it's going in a good way. Maybe I'm seeing somewhat empty, or maybe some unfair treatment happened with me, but I don't know actually what's the thing. He discussed this situation with his legal counsel, and, and legal counsel will most probably will say, okay, you seems to have a partnership interest in that business because you have been working along, you have contributed hours, and this relationship seems to be a partnership. So now if the person A knows about it, he would be thinking, come on guys, what you're doing means I have contributed money to this business, and I have just said to him, okay, we are just employees, I'm just using you, I'm just paying you after a month or so. So this should not be true. So you would also be probably thinking now, okay, means how this can happen. This can happen. Because of that, I just chose a name to be an accidental partnership. And I will just give you one of my favorite saying, and a very popular saying. If it acts like a duck, walks like a duck, then it's probably a duck. So you have to see the facts of your situation with the relationship you are continuing with person B. If that person B is contributing hours, thus the person B is getting kind of a split, maybe can be seen as a profit. Is that person B really acting as an employee? Is that person B coming on time or have a specific time to come in? Does the person B is getting a usual benefit like an employee? So this is very like a fact intensive analysis you have to do, and California law have different factors under it which are provided by different courts and decisions. So most usually one of the laws which is used, it's called Uniform Partnership Act, and now it's revised, it's called Revised Uniform Partnership Act. So it provides some default rules and also some rules to decide about when there is a situation of an accidental partnership, that if this person is a partner or not. So the factor would be making most common sense to an average person. Means if that person is contributing hours, how he's acting as an employee, he's contributing money over the time into the business, and just think about those kind of issues, and then you would be able to figure out, sure, means person A's lawyer would also be putting his own arguments. No, see, means both parties knew about it and they were just acting under impression of employment. But still, it would be a fact intensive analysis, and it's a big deal because the person B would be getting an interest in the business. If that business is generating thousands and thousands of dollars, millions of dollars, then there is a big issue about it. Means most of the projects you have seen, Facebook or other IT projects or even other businesses which have just started just as a project and they have been just grown a lot and just making a lot of money, and if you just come into that situation, then means you have a big issue to deal with. So what to do about that? So the most important thing, if you are hiring that person as an employee, just have an employment agreement. So at least later you would be able to show, okay, this person is my employee and he have been acting as an employee. And also make sure, even with employment agreement, it would help out to lay out a convincing argument. But still you have to make sure that you have the relationship with your employee as an employee. Because if the employee is contributing some things towards the business, still having an employment agreement would probably not help you. It would sure make a convincing argument, but it can go either way, because if the later acts of the employee and your ratification of that act, just trying to show a convincing factual situation that this person seems to be not an employee, this person is acting a partner, so then he becomes the partner and he will take his interest. And another thing, even if you want to be that person B as your partner, then just lay out in your partnership agreement all the terms. Just have a partnership agreement. It's really very, very important. If you don't dictate the provisions or relationship which you are having with that person, unfortunately your expectation would not be met, and your expectations will have to rely on the default rules of California, which is most probably would be different than which you are thinking. Suppose you have contributed $50,000 to just start this business and the other person didn't contribute anything. And you are thinking, okay, means I contributed this much money and this person would be only working in it and even getting salary. So I have 90%, this person has 10%. But later when the dispute happens, you don't have partnership agreement. So who knows how much percentage you have now. And now, so what happens? So California default rules will decide about that. Those revised Uniform Partnership Act rules will decide about that. Like who has how much interest and what are their duties and basic obligations. So you don't have now any control on this kind of relationship, and now you are in dispute. So in such a situation, for example, I will not lay out the whole act or different, there are like numerous provisions, default provisions, but just for example, we are discussing about the interest. So based on the default rule would be a 50-50% interest. You have both of in that partnership entity. You were thinking about 90%, so now you don't have 90%, and it's a big deal to just have expectation of 40% more and then just realizing that you are not legally entitled to that. Except there are some agreements or conversation you have which you can prove. If you don't have anything about that, then the default rule will apply. So now I think probably you are just trying to get the importance of having a written partnership agreement. It's really very, very important because you work really hard in your business and you should dictate the destiny and dictate the relationship under which you are getting into, and you should know about what the authorities you have under this relationship and what the authorities the other person have. So again, don't follow this video to solve your legal issue. Just talk with a legal counsel about your specific topic and just try to resolve that. And if you just need any help from us, we assist people in drafting partnership agreements. Or if you don't have partnership agreement and unfortunately you just entered into a litigation through a partnership dispute, we also litigate that. And again, you should work on your business, work hard, and just leave the legal worries to us. And whenever you have any questions, you can place comments on Facebook, YouTube, or other social media platforms. If you like to listen about any other legal topic you have interest in, so let us know. We can provide general legal knowledge, not specific legal advice. And so let's see you for the next video where I would be talking about the obligations of being a partner. As you know now how you can get screwed. So just see in the next video what obligations a partner has while working under the partnership entity. Okay, thank you.